Well, good morning, everybody. Thank you for joining on this wet and blustery day. It's 9:32, so I think we'll get started. We're quite keen to finish on time. I know everybody will have busy days ahead. So welcome, first of all, to our second webinar of the year. It's very nice to have you here. For those of you who don't know me, my name is Anna Robinson. I'm one of the partners in the team, and I'll be chairing this morning. It's very timely for me because I've fairly recently returned from maternity leave, so thank you. As always in employment law, we've got lots to talk about. It's sometimes said that the only certainty in our field is change, and as always, we're spoilt for choice as to what to talk to you about today. So we've got a whole team with us this morning. We'll start with Sarah and Devan, who will talk through some recent and upcoming developments. Elliott, I know, wants to talk to you briefly about some immigration changes we're expecting. And then Aarti and Emma will round up with some interesting cases from this year. I think Aarti intends to talk to you about the Patterson case, for example, which many of you may have read about. That's the case of Donna Patterson, who took on Morrison's and won successfully in her sex discrimination claim. And somewhat amusingly, she's been crowned as the Erin Brockovich of Bradford. And I know I enjoyed that case, and I'm sure you will as well when we come on to it shortly. Just a few housekeeping points, if I may, before we get going. It is a webinar, so it can be a little bit difficult to keep the session interactive, but we do love hearing from you. So feel free to use the Q&A function at the bottom to post questions, which we will go through at the end. But also any observations from trends that you've seen in your workplace. We'd love to hear about those. We will also run some poll questions as well, just to get a feel from you as to the trends that you've observed. If you've dialed in for any reason, I will talk through those questions, or the speakers will, so you can still follow. We'll send through the slides as well. You should have those shortly, so you don't need to make notes of everything. And we will add to that email a little feedback survey. And if you'd be kind enough to complete that, it does help us refine and improve our webinars. And equally, if you think of any topics that would be particularly helpful, do let us know, because we always talk through those and think about them when devising our next webinar. And finally, to let you know that we will be recording today's session. Okay, so we did have a few issues with Dev joining. I think to allow him time to get back online, what we'll do is skip a few slides and start with Sarah, and then we'll go back to Dev once Sarah's finished speaking. So Sarah, over to you. Thank you.
Thanks. Good morning, everyone. I want to talk to you about something that could have far-reaching implications for employment law as we know it in the UK, and that's my first slide, please. It's kind of boringly named, but it could have very important implications, is the retained EU law Revocation and Reform Bill 2022 to 2023. So when we left the EU, existing UK law derived from EU legislation remained in place as retained law. This meant that around 2,400 laws derived from the UK's 40-year membership of the EU remained in force post-Brexit. The bill itself provides that all retained EU law will automatically be revoked on the 31st of December next year, unless the UK introduces legislation that's going to retain it, rewrite it, or potentially even extend that deadline beyond 31st December. So what's going to happen next December is that we're going to have essentially a bonfire of a lot of EU law. And what we don't know at the moment is what it necessarily means, but it's quite a challenge for the government. So potentially they could kick the deadline into 2026 in certain cases. So rather than next December, this could happen in 2026, but I imagine they're going to want to do as much as possible as they can. It's expected that the bill will also give the UK courts much more discretion to consider departing from established EU case law. Can I have the next slide, please? So what it means is essentially post-Brexit employment law reform is on the horizon, and the bill means potentially significantly changes to UK employment law over the coming year, which could impact essentially the regulations that have been introduced. So among other things, things like working time regulations, agency worker regulations, fixed term worker and part-time worker regulations, and TUPE. I have the next slide, please. Thank you. Concerns have been voiced over whether it's realistic to review such a large quantity of legislation within such a tight timescale, essentially by December next year, and at the same time as a reduction in civil service jobs. But what we know is it's coming and it will make an impact. So we need a lot more information from the government about what's going to go and what's going to change. But I wanted to tell you about this because there are going to be changes, and we'll keep you updated as and when we know more. I have the next slide, please. So before I come on to the next topic, which is quiet quitting, I just want to be grateful if you could answer a question which will pop up on your screen shortly. And the question I'd like you to answer, would be grateful if you would, is, has your business noticed employees quietly quitting? And if you could press yes or no, that'd be really helpful. As you know, this is something that's been all over the media of late. And hopefully we get, so at least 33% of you seem to have noticed it, whereas 67% are saying not yet noticed it or did not answer. Thank you for that, appreciate that. It's quite an interesting number already have noticed it. So obviously there's been quite a lot of discussion in the media about quiet quitting, where workers simply do the minimum that's required and no more. And some employees, as you may know, have been urged to follow suit by content on TikTok, or at least the employees who take life advice from TikTok, which is obviously not that advisable. The phrase quiet quitting has even made it into the Collins English Dictionary list of words of 2022, along with permacrisis, sadly. However, it's not a new phenomenon, as you probably know, as managing people. Employees have been doing it for some time. However, it's thought that the pandemic has made more workers rethink their careers and work-life balance and made it ever more prevalent. And commentators think that it's a combination of lockdowns, more physical and mental distance from work, being furloughed potentially, which is overall has led to a resulting overwhelming sense of why bother for some employees. But as a business, what's important to understand is whether an employee's dissatisfaction is serious enough to result in them leaving their role, or whether it's simply arisen because of a need for recognition or to have more of a work-life balance. And with a few tweaks and words of reassurance, the relationship can essentially be salvaged. Next slide, please. So it can take various forms and shape, from reduction in productivity, just failure to turn up to meetings, lack of contribution to team projects, or arriving late and leaving early. And employee reasons can vary. It can occur when an employee feels undervalued, underappreciated in the workplace, or when they feel that their work-life balance is out of kilter or problematic. And in extreme cases, I guess it can also occur when they're experiencing burnout. By dialing down the work effort, employees feel as though they're taking back control, deprioritizing their jobs and redressing that balance. This type of disconnect isn't obviously great for businesses at all, but it does allow individuals to maintain their wages while looking for a better job, and helps them avoid the stress of handing in their notice, having to find a new job and turning the pay tap off. But if it does become an issue in your business, there's obviously the same employees then can't complain when their peers or even their subordinates, who aren't quietly quitting, advance financially and professionally, and they don't. Next slide, please. So I think, what can you do? We can focus on improving the employee experience to try and prevent disengagement. We can speak to our staff to discuss how best it can help them feel valued and appreciated in the workplace, particularly when we're working in a hybrid style. Regular words of encouragement can go a long way, but as we all know, managers don't often do that. Other employees might simply be bored and looking to take the next step in their career, and they don't feel particularly challenged, so they've thrown the towel in. I think it's important, if that is identified, then it's important to put an effective plan in place with the employee so that they know what their next step is in terms of where they want to go with their careers or whatever. And the key is essentially to make sure that people are engaged in their work and that their work provides purpose and meaning for people. We all need to feel part of a bigger picture, and we all need autonomy and control in our roles. And workloads obviously should be realistic, and there should be perhaps appropriate boundaries in place between work and home, which that's kind of blurred during the pandemic and beyond. And obviously, ideally, mental health should be made a priority in the business so that you don't end up with lots of sick days and people who have reached crisis point. Next slide, please. So dealing with it, employment lawyers are only likely to get involved if the disengagement is such that it spills over into poor performance. But it's unlikely to be the case if an employee is doing all that's asked. And that's one of the problems with this, is that if they're just doing what's required, then what can you do about it? Or if the lack of motivation strays into misconduct, but again, that we'd only be able to do anything about that if the employee's behaviour at work was unreasonable. I think the key to dealing with it is to understand what has led to the change, or at least to try and find out. And I think before launching into disciplinary action, it's probably often worth considering an informal meeting with the employee before starting that. Employee motivation engagement will, of course, fluctuate. It ebbs and flows. We shouldn't expect it to be constant. And there may be outside factors that you're just not aware of that are impacting their behaviour. But I guess this quiet quitting seems to be another challenge for employers in the hybrid working world. Next slide, please. The next thing I want to touch on is just some changes in terms of equal opportunities in respect of pay reporting, and the first thing I want to talk about is gender pay reporting. So there is possible government review of the gender pay reporting regulations at the moment. Essentially, the reason behind that is for the government to assess whether the current requirements achieve the objectives of the regulations, whether they place an unnecessary burden on employers. But one thing that piqued my interest was, one suggestion is that there would be an introduction of financial penalties for failure to comply with the gender pay reporting regulations. However, that's not yet come in. And in the meantime, to help reduce the pay gap, the government has launched or is launching a transparency pilot. As part of that pilot, participating employers commit to listing salary details on job adverts and removing questions about salary history during the recruitment process, among other things. Next slide, please. The next thing that you're probably aware of and have been thinking about when this would be introduced is ethnicity pay reporting. Now, this is going back to 2018 when this was first mooted, but in its policy paper published in March this year, the government stated that it would not be making ethnicity pay reporting mandatory at this stage because it wanted to avoid burden the post-pandemic recovery. As such, the government has essentially reversed a previous commitment to introduce this. And what the government is instead doing is pushing forward with the voluntary regime that you can either decide to participate in or not. The government is also said to be developing guidance, which we were told was going to be published in summer this year, but it hasn't transpired yet and we still haven't seen it. But for some employers where it is helpful to your business, they are still pushing ahead with this. And I guess where they think it's beneficial, they are differentiating themselves from competitors by doing this already in advance of any legislative changes. Next slide, please. And just finally, I wanted to just tell you about something that is not quite here, but it will be potentially in the future, and that is disability reporting. The government had a consultation earlier this year on the potential introduction of mandatory disability reporting for large employers. And that suggested that large employers would be required to report on the number of disabled employees they had in their workforce and potentially the kinds of disabilities that they have. And the reason for this is that, unfortunately, in the UK, a disabled worker is paid on average 13.8% less than non-disabled workers and is far less likely to be in work. And the government wants to try and address that. But there are challenges because, of course, 80% of disabilities are invisible. And as you probably have already experienced, employees are often unwilling to disclose medical issues and or the existence of a disability. And we anticipate that it may prove challenging to find a reporting method that accounts for the wide range of disabilities that people may have. And now I'm just going to hand over to Anna, who will introduce our next speaker.
Thanks, Sarah. I think the quiet quitting that you talked about is particularly interesting. And I was surprised actually to see that a third of you, which is quite high, see this as a problem in your workforce. What we're noticing is quite a lot of queries in our team about getting people back into the office. And I know Aarti will talk about that shortly, but I think the two are clearly connected, and it seems to be a trend which I'm sure will develop over next year and beyond. I'm delighted to say we now have Devan, and he will talk to you about IR35 to start with. We just go backwards and clear up the latest confusion. And he'll also talk a little bit about remote working. Dev.
Hi, Anna, thank you. I'm also a quasi-tax lawyer today because we'll be talking about some of the changes which are effectively in relation to tax but impact the employment space. And the first one I want to talk about is the IR35 off-payroll working rules. And not because there is a change necessarily, but because there's a lot of confusion around this. With the unprecedented changes in government that have taken place over the last few months, there's been a bit of a hokey-cokey as to what's going on with the IR35 rules. So just going back to basics on IR35, essentially this is a tax avoidance rule designed to combat disguised employment. So effectively what that means is where you have consultants or contractors, an HMRC decide that they are really employees to all intents and purposes. This is a mechanism by which HMRC can ensure that these individuals of some or other are paying tax as an employee. So you've got PAYE, you've got national insurance contributions, etc. And this is the mechanism around how that works. That's separate from employment status. There is a difference on the tax side. Now, just to clarify, there's often a lot of confusion around IR35, but it applies to the contractors and consultants who are providing their services through their own limited company or some type of intermediary. So if you don't have that thing in the middle, that intermediary in the middle, then IR35 is not what applies here. Okay, so it's important to understand it's only where consultants are using some sort of personal service company or intermediary. Now, where you have that scenario, who's responsible for making these deductions? So the chart on the next slide will show the different ways, parts of that. So you've got the consultant at the bottom, you've got the intermediary, and you've got the end user. And the contract is often between the end user and the intermediary there. Now, under the rules as they were for many, many years, it was the intermediary that was responsible for the tax. So if HMRC turned around and said, that consultant is an employee, well, in that case, they will go to the intermediary, that personal service company, and say, you need to deduct PAYE, you need to deduct national insurance contributions, etc., and make that contribution to the Treasury. Now, there was a large change in April 2021, which applied to the private sector. It previously already applied to the public sector. And the next slide, we'll talk about that. Sorry, just moving on, yeah. So they shifted that burden from the intermediary to the end user. So from April 2021, if you engage a consultant by a personal service company and HMRC think that that individual is actually an employee in reality, they will come to that end user, the person at the top, the person benefiting from those services. And that's where the PAYE and tax obligation is. So that was quite a major change. And this is the perfect time for our poll question. So, since the off-payroll working rule change in April 2021, a question for you: do you still engage consultants? Yes, no, not since April 2021, or you never have engaged consultants. So please respond. It'd be interesting to see what the situation is. Okay, that's interesting. So actually, there's not been a massive change in people's working practices. They are still engaging consultants. 76% of you still do that, which obviously there's some additional obligations now, status determination statements, tightening up the documentation around it. So it looks like people haven't been put off. We know certain industries, I know in the financial sector, for example, some banks took the decision to basically stop doing that, but it seems like many of you have not. Now, the reason why we're talking about IR35 today is because there was some confusion around this. When the mini budget was announced on the 23rd of September, what you had was the government saying they're going to get rid of those changes in April 2021. So basically, it's going to move back to what it was before. So the intermediary would be responsible for the PAYE. But Jeremy Hunt reversed that on 17th of October and said that no, the rules that apply in April 2021 will continue. So it's still going to be the end user. So those additional obligations that are on you when you engage consultants via an intermediary are still there. And that's the current position for everyone. And there's been no hint that that's going to change, given the sort of focus on increasing tax revenue. So just moving on a couple of slides, please, to the next one. So there you go. You can see that that's the end user that's responsible. Now, on the next slide, I've got a list of criteria that are taken into account by HMRC. I'm not going to go through these. They'll be on your slide pack that you've received, but these are the kind of criteria that HMRC look at. Now, moving on to another tax-related issue that impacts employment. We all know that COVID has massively impacted the way we work. So next slide, please. So obviously, working from home became the commonplace for many industries. And now as things have opened up, there's definitely a lot of still continue working from home or hybrid working. I know some employers have gone back to the office fully. So this has completely changed our working pattern. But another unique change is people working across borders. Now, traditionally, there's always been people who work abroad, who've been sent abroad to another country on behalf of their employer to work in a different country. But what's happening now is we're seeing a trend where individuals are saying, I actually want to work in a different country. I can work from home. I can work from anywhere. I want to work from Spain or Portugal or France or Germany or somewhere else because perhaps my partner is being relocated there, or for lifestyle reasons, or because I have family there, et cetera, et cetera. And it's not necessarily linked to the employer. Now, this causes lots of complications. What happens with respect to that individual? What tax do they pay? Which jurisdiction applies? What about Social Security? Who's responsible for those tax deductions? Is it the individual, or is it the employer? And there's implications also for permanent establishment. Do you create permanent establishment? Does that company have a presence now for tax purposes in that country? And one of my tax partners has been saying for quite some time he expects the government to look at this, and that's exactly what is happening now. The Office of Tax Simplification is conducting a review. They've asked for public feedback, and that deadline for that is gone now, but they are now analysing all the feedback they've got and are expected to report soon, perhaps by the end of the year. And so we do expect HMRC to turn their attention to this now and look at the taxation of employees who are working across borders, particularly, given the increased focus on tax, as I mentioned. Moving on to the next slide. So just looking at the kind of things the review will focus on. So we'll look at the tax on individuals. We'll look at accommodation, travel and other expenses. It will look at short-term business visitor rules. It will look at permanent establishments, but also look at other things such as pension and employee share schemes. A lot of these are tax advantaged, depending on, they're designed to be tax advantaged to the individual. But do you still get that tax advantage where you are based abroad? So it's a case of watch this space. We'll have to see what's reported on, what the recommendations are, and what part of that HMRC and the government take up. But yeah, it's the question of watch this space. So back to you, Anna. Thank you.
Thank you, Devan. It may be that we revisit this in future and we ask one of our tax partners to join us, because certainly it is another trend and another question that we're very commonly asked, and that applies to our overseas employment partners as well. So it's definitely a hot topic, and I'm sure will continue to be subject to change. So moving on, if I may, I want to turn to Elliott now. Many of you will know Elliott. He's our resident immigration expert, and as usual, the government can't leave immigration alone. So Elliott was just going to give you a very brief update on where we are with that. Elliott, over to you.
Thank you, Anna, and good morning all. I'm going to start my review of recent immigration developments just by touching on some of the recent sort of high-level immigration discussion that's been touted by our successive prime ministers. I started writing my first slide when we had a different prime minister, and it's since been gutted by the latest leadership changes. Nevertheless, Liz Truss's brief tenure as PM did introduce some radical high-level plans to overhaul the UK immigration system. She was gone before she had a chance to add any meat to the bones of those ideas, and we now have Rishi Sunak leading the country, and therefore the policy changes that she had touted have been disregarded. The government's focus is largely on refugees at the moment, and the wider immigration policy hasn't really been discussed in any detail beyond the sort of usual calls for reductions in net migration. So we're very much in a watch this space holding pattern at the moment. Moving on now to a significant development over the summer and the introduction of a new scale-up visa route in August. So the aim of the route is to give growing businesses the opportunity to recruit overseas workers, and to qualify, they need to prove that their turnover or staffing have grown by 20% annually during the previous 3-year period. So once they've applied for their sponsorship license on that basis and they've been approved by the Home Office, the business can then offer candidates a job in an eligible occupation for at least 6 months. They'd need to assign a certificate of sponsorship database record, which details the UK role the individual will take. So that's sort of similar to the skilled worker regime. And the individual who's taking on the role would need to be paid whichever is the higher of the appropriate rate for their occupation, or $33,000 per year. The applicants would also need to prove their English skills and that they have enough money to financially support themselves in the UK, which is a similar maintenance principle, again, to the skilled worker route. That visa is then valid for 2 years and can be extended until the individual is eligible to settle. The big difference with the skilled worker regime is that after 6 months of employment with the scale-up sponsor, applicants can switch to another role for another company in the UK without needing a new visa, or they can change roles within the same company. They could also study and become self-employed while holding the scale-up visa. And that offers them an advantage where the skilled worker visa doesn't. The skilled worker regime has limitations on who an individual can work for, the extent to which they can study or work for another company during their sponsorship, and also limitations on the roles that they can perform for their sponsor, where they would need to apply for a new visa if their role changed substantially, for example. So that concession offered by the scale-up route could be an attractive alternative to both qualifying businesses and individuals, particularly those that are perhaps startups and, you know, in the infancy of their business, where their growth is substantial enough for them to qualify. In lieu of any other significant immigration developments, I just wanted to offer in my final slide just a few more practical insights before leaving you. Many of you listening, I'm sure, will have seen or felt the uncertainty caused by the unpredictable visa processing times over the summer months, when a combination of factors, which included Ukraine, COVID, Brexit, and so on, led to the suspension of priority services and visa delays of several months. And we were seeing visa delays of 3, 4, 5 months in some cases. So the Home Office is currently indicating that visa processing times are taking up to 16 weeks in some cases, although the reinstatement of priority services for work visas does mean that there is a way of expediting that, albeit at a cost. You can't use priority services in all cases, so it is important to keep a critical eye on the circumstances and the timing of the application to manage the individual's expectations accordingly, and also manage the business's expectations as well, particularly where you're dealing with new hire candidates who need to fill a vacancy within the business within a set time frame. As a final note on this sort of whistle-stop tour, we've seen some anecdotal evidence that European nationals in particular are facing greater scrutiny by the border force on entry to the UK. That's not entirely unforeseen, as since the end of free movement, the authorities are looking more closely at individuals who are entering the UK for business and tourism, and we're seeing them asking more pressing questions around the nature and the duration of their visit. So it is important that steps are taken to mitigate against those risks. That draws my very brief update to a close. So I will hand you back to Anna. Thank you.
Elliott, thank you. I think Elliott would agree with me that we can't really stress enough how important it is to build immigration into your recruitment timelines, because the processing times are so long at the moment, and there's not really any sign of that getting better. So do think about that and involve your immigration advisors at the earliest opportunity to avoid any delays with start dates. Great. Okay, thanks, Elliott. We want to turn now to talk about some cases, starting with Aarti, if I may, and then Emma will wrap up the session. We haven't had any questions yet, by the way. Do feel free to post those on the Q&A function, and we'll turn to those at the end. Aarti?
Thanks, Anna. Can I have my first slide, please? Morning, everyone. So I'm going to look at a couple of interesting cases this morning. The first one being Rogers v Leeds Laser Cutting Limited, which involves return to the office during the pandemic. And this case addresses the really hot topic of how an employer can bring an employee back to the office, and if there are any risks associated with that from a tribunal perspective, particularly from the point of view of health and safety concerns post-pandemic. But we're going to start with a quick poll just to get an indication of what your business is doing at the moment in terms of getting people back into the office. So that will pop up shortly. So what is your working from home policy? Employees have total flexibility on when to attend the office. They must attend the workplace on specified days, or they must attend the office full time. So if everyone can cast their vote, that would be great. Oh, that's very 44% say total flexibility and 44% say work on specified days. 12% attend the office full time. That's really interesting. And we are actually seeing a shift towards employers asking employees to attend the workplace on specified days. So it's very interesting that there's still quite an equal split between those who are required to attend on specified days and those who are able to work flexibly. So that's good to know. Thank you everyone for voting. So yeah, just moving on to the case in question, which is Rogers. In this case, it was an EAT decision this year. It looked at whether the employee, Mr. Rogers, had protection against unfair dismissal when he refused to attend work due to COVID-related concerns. And in this particular case, Mr. Rogers didn't actually have 2 years service, so he wasn't able to bring an unfair dismissal claim or an ordinary unfair dismissal claim. So he had to rely on legislation which protects employees in circumstances where the dismissal is on health and safety grounds. So his argument was that he took steps to protect himself or others in circumstances where he reasonably believed there was a serious and imminent danger posed by COVID. And the facts of the case are as follows. Mr. Rogers refused to attend work after his colleague started showing symptoms of COVID, and he stated that he was concerned for the health and safety of his young children who were medically vulnerable. And after a month of refusing to attend work, he was then dismissed by his employer. The case first went to the Employment Tribunal, and the Employment Tribunal dismissed the claim on the basis that the mere existence of COVID was insufficient to create a serious and imminent danger in the workplace, which couldn't be avoided. And on the facts, Mr. Rogers' refusal to attend work was therefore not reasonable. Next slide, please. It was also relevant to the decision by the Employment Tribunal that the employer was found to have complied with the Working Safely government guidance, which was in place at the time, which included things like social distancing, wiping down surfaces, staggering arrival times, providing PPE, and the employer had also carried out a thorough risk assessment. So the tribunal also found that Mr. Rogers' behaviour actually was inconsistent with his alleged concerns around COVID, in that he was found to have breached self-isolation guidelines himself during his period of refusal for work. He failed to raise specific issues at work, and he couldn't show that there was a greater level of danger in the workplace than there was outside of it. So on that basis, the tribunal dismissed his claim. He then went and appealed to the EAT, and the EAT then upheld the tribunal's decision. So the EAT made it clear that for Mr. Rogers, no such reasonable belief of serious imminent danger was found, and that he could have taken steps to avert those risks both at work and outside of it. So what does this mean for employers? Now, although it does provide a sense of relief to employers who want to bring employees back into the workplace, we probably should stress that employers must remain mindful that this case was very fact specific, and any concerns about attendance in the workplace should be dealt with on a case-by-case basis with a view of finding mutually satisfactory arrangements. And if those arrangements can't be agreed and dismissal is contemplated, then employers shouldn't overlook the ordinary unfair dismissal principles of, a fair reason and fair process. Because although the 2-year, he hadn't been employed for 2 years in this particular case, so he wasn't able to bring an unfair dismissal claim on the ordinary grounds, and this won't always be the case. So it's really important to be mindful of those when contemplating how to deal with employees who might not be happy or willing to come back to the workplace. Just to note that permission has been granted for an appeal to the Court of Appeal, so watch this space as there may be further developments in this area. Next slide, please. So the next slide that Anna just touched on in her introduction is Donna Patterson and W.M. Morrison Supermarket Limited. And in this case, the claimant, Ms. Patterson, took the supermarket chain Morrison's to tribunal after arguing they had indirectly discriminated against her and unfairly dismissed her. And she represented herself during a 5-day trial with no legal training and won over £60,000. Now, this is an interesting case because it's not often that we see employees bring discrimination claims in the employment tribunal against their employer without any legal representation or training, and certainly not where their employer is a large supermarket chain and a household name such as Morrison's. But in this case, the claimant decided that, notwithstanding the fact she couldn't afford legal representation, she believed she had a strong case and she took the resources available to her and she was successful. Just briefly to discuss the facts. So there were 2 main issues that led to her complaint. The first one was that Morrison's had rescinded a job offer for her to become a confectionery buyer after she revealed she was pregnant. And the judgment found that Morrison's unfairly treated her in the circumstance because it actually took into account the fact she was exercising the right to maternity leave when consulting with her about the job restructure. Secondly, she argued that when she returned from maternity leave, she was expected to work a full-time job despite only being contracted for part-time hours and part-time pay. And this was held to be a detriment of indirect sex discrimination, as Morrison's applied a PCP or provision criterion of practice, which was applied equally amongst all its employees, but placed or would have placed women at a particular disadvantage compared with men. And it did so in this case for Ms. Patterson. So following a period of sick leave due to stress, she raised a grievance, which was not upheld, and then she resigned and brought a claim with the Employment Tribunal. And amazingly, she opted to represent herself because she was unable to afford legal representation, although she did work with a campaign group called Pregnant Then Screwed, which I'm sure would have provided a lot of helpful information to her about her rights being a new mother, and also as to how to pursue the claim, even though they obviously wouldn't have provided her with legal advice as such. She also told reporters when asked that she read up on comparable cases, which helped her understand how the tribunal would proceed, what tactics her employer solicitors would use, the language of legal representation, and she actually cross-examined 8 witnesses during that five-day hearing, all of whom were former colleagues of hers. She was then awarded just over £60,000 as compensation for unfair dismissal and discrimination, which is a staggering amount. So, well done to her. She did amazingly well to achieve that result. In response to the judgment, Morrison's have stated that they're considering an appeal. And unsurprisingly, Ms. Patterson has said that if they do appeal, she'll represent herself again. Now, this is really just an interesting case to remind employers that the absence of legal representation is not necessarily a bar to a successful employment tribunal claim. And in fact, defending a claim against the litigant in person is sometimes more difficult and costly for employers, as the tribunal will generally take a more sympathetic view and expect employers to assist the litigant in person, where this wouldn't necessarily be expected if the claimant was represented. Also, it's a very important reminder that having the resources to fight a litigant in person doesn't necessarily mean that it's the best approach, as this case highlighted. And that's the end of my whistle-stop tour on those two cases. So back to Anna.
Thanks, Aarti. There was a really good interview with Donna Patterson on Woman's Hour, which I particularly enjoyed. She's really quite an impressive individual. And I suspect that Morrison's won't appeal, because I don't think it's particularly good PR for them, but we'll see. But yeah, a very interesting interview. I particularly loved the name of the campaign group. I thought that was very good. Great, thank you. We're just going to wrap up now with a few more cases, this time from Emma. We've had a few questions, but as I say, do keep them coming. Emma, over to you.
Thanks, Anna. So I'm going to discuss two important cases, one dealing with holiday pay, the other dealing with voluntary redundancy. And the first case is Smith and Pimlico Plumbers. This case is significant from a holiday pay perspective. So I'll just start by talking through the facts. Smith was a plumbing and heating engineer working for Pimlico Plumbers Limited. In 2011, he brought claims for unpaid holiday pay under the working time regulations, as well as unauthorised deductions from wages under the Employment Rights Act. Pimlico Plumbers disputed Smith's employment status, and the case went up to the Supreme Court, which held that he was a worker under the working time regs in the Employment Rights Act. The Supreme Court then remitted the holiday pay claim to the Employment Tribunal. However, the Employment Tribunal found against Smith. Then he unsuccessfully appealed to the Employment Appeal Tribunal. The Employment Appeal Tribunal said that if a worker takes leave, even if it's unpaid, they have at least partly exercised the right to paid annual leave. And you might think that sounds strange. Indeed, the Court of Appeal overruled the decision, holding that a worker can carry over a right to payment for annual leave from one leave year to the next. It said that at the point of termination of their contract, they're entitled to a payment in respect to the untaken leave. The worker would lose that right if they had the opportunity to exercise the right but did not do so. The judgment states that the burden is on the employer to show that it specifically and transparently gave the worker the opportunity to take paid annual leave, it encouraged them to do so, and it informed them that they would lose the right at the end of the leave year should they fail to take it by then. The Court of Appeal addressed the timing of Smith's working time regs claim, albeit not too explicitly, indicating that as long as a claim is made within 3 months beginning with the date of termination, and that's the key part, it'll be in time. And in fact, the working time regs do allow for cases to be brought within such further period as the tribunal considers reasonable, where it's satisfied that it was not reasonably practicable for the claim to be presented within 3 months. Therefore, we can assume that holiday pay cases could, in some circumstances, be brought more than 3 months after the termination date. Finally, in respect of the unauthorised deductions from wages claim, the Court of Appeal noted that the argument that a series of deductions from a worker's wage would be broken by a gap of over 3 months between deductions was wrong, albeit this was not a binding view. It's worth noting that Smith did not plead payment in respect of the paid leave to which he was entitled as a worker, but did not take. However, the EU law case of King and Sash Window Workshop in this judgment indicates that leave also carries over where it's not taken at all. Next slide, please. So this case is relevant to the engagement of contractors. If an employer treats someone as a contractor, when in fact they're a worker, they could end up with such claims being brought against them. And claims could also arise where employees do not end up taking their 4-week statutory annual leave entitlement under Reg 13 of the working time regs, simply because they're busy with work and their employer doesn't encourage them to do so. It's important for employers to ensure that their employees take annual leave regularly for a number of reasons. Firstly, It's more likely that there'll be clashes of requested leave dates and more staff on leave than usual at certain times, such as the end of the leave year, if leave isn't taken regularly. And this can naturally lead to conflicts and low morale if the team's understaffed. It can also lead to conflicts and low morale if employees have to reject leave requests, meaning employees cannot take leave on the dates they want. If an employee does not have sufficient breaks, and this results in poor mental well-being, there's potentially the argument that the employer has not complied with its health and safety duties. Further, if employees are off work due to stress, this can lead to understaffing and may have an economic impact on the business. And it could be costly for an employer to have to pay employees for annual leave on termination. This is especially the case if an employer undertakes mass redundancies. So what should employers do? Well, they should ensure they have clear annual leave procedures and policies in place. HR managers should ensure that leave is monitored throughout the leave year and that employees are regularly reminded to request annual leave. And one-to-one follow-up as required is also advisable. Next slide, please. So the next case I'm going to speak about is White and HC1 Oval Limited. And this judgment was published in April this year. This case is a reminder that an employee who volunteers for redundancy can still be successful in an unfair dismissal claim. The claimant White worked part-time as a receptionist at a care home. Her employer provisionally selected her for redundancy as part of plans to decrease the number of employees undertaking receptionist and administrative duties. White took voluntary redundancy and her employment accordingly ceased. White claimed that her employer had unfairly dismissed her. She didn't accept that there was a genuine redundancy situation. The Employment Tribunal, however, struck out White's claim on the basis that it had no reasonable prospect of success. Next slide, please. White successfully appealed the Employment Tribunal's decision at the Employment Appeal Tribunal. The Employment Appeal Tribunal said that the Employment Tribunal's reasoning in its ruling appeared to assume that every voluntary redundancy would automatically be a fair dismissal, and or that by volunteering for redundancy, an employee would lose the right to claim unfair dismissal. It affirmed that such assumptions were incorrect as a matter of law. As White and the employer disputed the central facts regarding the fairness of the redundancy process, the Employment Appeal Tribunal was of the view that the Employment Tribunal should not have ruled that White's unfair dismissal claim had no reasonable prospect of success. The Employment Appeal Tribunal remitted the case to an Employment Tribunal for a full merits hearing. Now, of course, in most cases, the relationship between the employer and the employee will be amicable and straightforward where the employee volunteers for redundancy. Nonetheless, this case is a good reminder that employees who are volunteering have the same statutory rights as those who are not volunteering for redundancy. Therefore, employers need to treat such employees with care, and they should make sure that they always act fairly in redundancy situations. Now I'll hand back over to Anna.
Hello, thank you for that. Righty-ho, we've had some questions. So I want to dive straight into those so we can get through them in the time that we have left. Can I start with you, Sarah? This is a question on quiet quitting. I thought this might cause some of you to ask questions. And it's a general question, which is this: what can we do as employers to try and prevent this theme, this trend of quiet quitting? What practical advice do you have?
I think there's a variety of things that you can do. I think the first thing to do is to try and identify which sections of your business are quiet quitting or liable to. And I think there's been quite a lot of research into this, and it suggests that it's more likely to be younger employees, those born after 1989. So it may be that you focus your efforts on that section of the workforce. I think a focus on recognition for employees pays off long term, and I think you'll see dividends if you engage in that. I think when employees see the value of going above and beyond, they're more likely to do that and stay engaged. And I think there's some soft things around that you can do that won't necessarily cost money. It's just kind of explaining to employees to understand the impact their work has on colleagues and the success of the business. And that's around communication. I think managers should also be encouraged to connect more often with employees, especially those remote workers. And I think there's been a tendency for some managers not to do that, and then things get worse.
Yeah.
A LinkedIn report suggested recently, and the percentages are quite surprising to me. They said that 94% of the people they surveyed said that they would stay in a job longer if they had access to career development and they could see their path within the business, as it were. So I know that some employers who are a little bit ahead of the curve in this have started to offer a more transparent view of jobs company-wide, and they publish key competencies that are needed for the employees to succeed in those roles, so that people can see what they need to do, what criteria they would have to satisfy in order to get there, and that it's not this kind of unknown, kind of vague, wishy-washy. It's kind of there in black and white, and then they can kind of take control of navigating their careers and visualize and take practical steps to ensure that maybe they position themselves and put themselves in the best position to get there. So I think there are some practical steps you can do, but I appreciate it is a difficult situation.
I think it's about, as you say, it's about communication, it's about transparency, particularly around the career progression piece. I think those employees that are going above and beyond, they need to be rewarded appropriately, don't they, in terms of the bonus scheme and how those targets are set out in your bonus policy. And also, well, I've noticed from my clients that a lot of companies now are using employee engagement surveys and on an anonymous basis to try and get some info from staff as to what they want in this new, post-COVID world, and that can be incredibly insightful for the employer. If the employee gets assurances that the information they give will be treated confidentially, then that's the best possible source of information.
I think that some employers have also kind of moved towards kind of more regular appraisals, rather than we find out at the end of the year how the employee is thinking. They're having more regular, kind of more informal, quicker check-ins with the employees during the year, so that if there are issues, they can try and see those off before they get so bad that they're polishing their CVs, answering the call from recruiters. And then you've got people leaving and the associated cost of recruiting them in an already difficult job market where, there are certain skills that are in short supply. So I think those things are all helpful. I do think the younger generation do expect feedback regularly. It's more instantaneous than perhaps it used to be. So I think you're absolutely right that sometimes the appraisal system needs to be completely overhauled, and that's certainly another theme that we've noticed. Thank you. Elliott, can I move on to you? It's a question about visitors, if I may. Can we see you? Aha, there you are. What can individuals and businesses do to mitigate against the risks of a visitor breaching the terms of their visa?
Sure, and that is a question that comes up a lot, whether it's through concern or through necessity of someone having been stopped and questioned at the border, which we are, as I alluded to, we are seeing more and more. I think our general advice would be to support any business trips with an invitation letter. So the business who is bringing the individual to the UK should send a formal letter on headed paper, which explains, the rationale for the trip, the dates, and so on, and some other key information that would be carried by the individual when they travel, and would be shown to the border force if they were asked the question. On a practical point as well, the individual, I would say, should avoid frequent and successive trips. That would tend to be able to work in their favour, as the more frequent the travel to the UK, regardless of what the reason is, it's going to draw attention to a pattern of visits and could potentially arouse suspicion of someone having transferred their base to the UK, which is what is really the key that you want to avoid. Another important point is not to overreach in the activities that the individual's doing when they're in the UK.
There's a lot of confusion around that, isn't there, Elliott, I think, as to what business visitors can do?
There is, and it's always been a bit of a grey area, and I think I think the Home Office intentionally don't offer comprehensive guidance on what you can and can't do. What one person thinks constitutes work wouldn't necessarily tally up with what the Home Office would think would constitute work. But I think generally, if you avoid kind of rolling up your sleeves and getting involved in inactive sort of transactional matters, then you should be fine. Limiting it to training and business meetings is another positive. But also just understanding the limitations of the visit, both the business and the individual themselves, so that there is no confusion around what they can and can't do and how long they can stay for and that sort of thing. So really just knowing the route and having good, clear communication with the person who's visiting and the people who are going to be meeting with them in the UK, I think is the most important thing overall.
Yeah, okay. And also European nationals, of course, need to be careful. Yeah. Thank you. Right, just looking at the new questions which have come in. I think this one's for you, Aarti, if I may. So it's a good question. Would an employee be protected from attending work due to their partner having cancer due to COVID concerns? So they don't have the cancer, but they're caring for somebody who does, and how would that work vis-a-vis the Equality Act, I suppose?
Yeah, I think this is obviously very fact specific. So the answer also will be that it very much depends on the facts involved. But I mean, as a general point, I guess there's 2 points. You mentioned the Equality Act, Anna, but there's also the point about, I guess, linking to the Rogers case, the dismissal on the basis of refusal to attend work. So I think, I don't think an employee is automatically going to be protected in these circumstances. And I don't think they'll be safe to say, I can't attend the workplace due to my partner having COVID, my partner having cancer, and being concerned about the risks of COVID. Because I think the Rogers case did give us quite a few helpful insights on this basis. I think an employee would have to show that the reason why they can't come into the office is because of a real serious and imminent danger. And I think from the Rogers case, the tribunal and EAT found that COVID in itself is not grounds for a serious and imminent danger. I don't think going forward, the tribunal will see COVID very differently from any other kind of serious illness. So on that basis, I think an employee would have to show that it's actually more dangerous for them to be in the office than it is outside the office. Because if this employee in question is, carrying on their life as normal, going shopping, going on holiday, visiting friends, visiting restaurants, it'll be more difficult to show that, I'm doing all of that, but I can't come into the office because I'm concerned about the risks of COVID in the workplace. So there'd have to be some real reasons as to why the workplace is more dangerous than outside the workplace. So I guess that would again depend.
I think you're absolutely right, but obviously the employee would have rights as the carer of if we assume that the person with cancer has disability, because we know it's automatically classified as a disability, then as a carer of that disabled person, the employee has rights under the Equality Act by association. So exactly. I agree with what you're saying, but I suppose the employer does have to tread carefully because of the discrimination angle.
Yes.
And I wonder with this whether, I think you're right, but it might be that a pragmatic solution is some kind of flexible working request that's agreed formally and constitutes a change to their T's and C's, as opposed to uncertainty about how they follow the agile working policy, which can cause all sorts of problems in the team.
Exactly. There might be other adjustments that need to be made, for example, working in a particular, because it depends on the industry that this person is in. If they're in an industry where, COVID is rife, or where they work very closely with other people, and it's not possible to make those adjustments to make it safer, then obviously it's very different from an employee where they sit in their own office and they hardly have to interact with other people. So again, that's where it depends as well. But like you said, flexible working requests, or just for adjustments to say that if I do come in the office and I'm concerned about the risks of COVID, are there adjustments that can be made for me, even though there's no legal obligation to make an adjustment for someone who's not themselves disabled, but an employer could still consider adjustments to make it safer for that employee to protect their vulnerable their partner who's suffering from cancer.
I think the employees are often concerned about the tube, aren't they, and the transport network, as opposed to the safety of the office environment. But as you say, that's something for discussion. Gosh, we've actually run out of time. Can we squeeze one more in? I suppose anybody that needs to go, do go. Just, I guess, another one for you, Aarti. So can flexible working continue on an ongoing basis indefinitely, or at some stage should contracts be updated to reflect that although office is the normal place of work, they can work up to a certain percentage of time at home? And what about if someone is continuing to work at home 100%? Should the contract be amended for that person?
Well, I guess the main point is that once the contract is amended, that is their new terms of employment. Yeah. So if the intention is that, you know, flexible working will continue indefinitely, then, you know, perhaps that is something that could be discussed and the contract could be amended. However, if there's a chance that might, you know, an employer might want people to be back in the office 5 days a week, because we don't know what's going to happen in a few years' time, it's probably better not to amend the contract, because then if you do want to revert back to office working, you then have to do another amendment, which employees are probably less likely to be agreeable to if you're, you know, going the other way and bringing them back in. On the other side, you know, if someone is working flexibly in a fixed pattern where they work 2 days from home, 3 days from the office, and that goes on for a long period of time, then actually it could be that their contract is amended. You know, it's an implied term of their contract that they are now, you know, working half in the office, half not. So you might not necessarily have to make that formal amendment, but they could argue down the line, if you tried to change it, that their contract is now half in the office and half from home without actually making that formal amendment. So I guess the answer is, it depends on the circumstances. It depends on whether the intention is for this arrangement to be indefinite. If you're not sure and it's something that, you know, it's evolving, then it's probably best to leave the contract as 5 days in the office, because it just gives the employer that flexibility to insist that employees work in the office, because, like I said, it's harder to go the other way and to bring employees back if the contracts don't say that you have the right to do that.
But monitor what's happening, so in implied terms. Okay, great. There have been a few other questions. We will respond to those people by email. We will get to those. Apologies that we've run out of time. Just a couple of final points before I leave you. If you've dialed in, please can you email our events team at events@wfw.com, just so we've got a record of you attending. And just to say as well, we will be emailing our feedback survey if you'd be kind enough to fill that in. Great. Well, thank you, everybody. Thank you to the speakers. We look forward to seeing you at the next session, and enjoy the rest of your Wednesday. Goodbye. Thank you.